The Constitutional Court last week dismissed Adv Busisiwe Mkhwebane's bid to appeal the so-called SARS rogue unit ruling. Now, the Apex Court said the appeal does not have a reasonable prospect of success. And remember that the Public Protector released a report in 2019 and it found that an unlawful unit existed within SARS. But of course, this report was then set aside by a lower court, and she was then seeking to appeal this particular ruling, but the Apex Court agreeing with the lower court here. Let's speak to Bernard Hotz, who's the lawyer representing former top SARS officials. Thank you so much for your time this afternoon. Let's start first with your client's reaction to the ruling.
Good afternoon. Thank you so much. As I've said, it's rather bittersweet. It's sweet because eventually justice has prevailed. It's bitter because one sees really the decimation that was caused through the process we now call and know as state capture. So yes, it's good that justice has eventually prevailed. As you've correctly said, the Apex Court has said that the ruling of judges Selby Bakwa, Wendell and Basson is in fact correct, and that there's no reasonable prospects that another court will come to a different decision. And this really heralds the end of the road.
You talk about the decimation, and this is a matter that has been quite topical since the first reports then, emerged. Can this decimation be undone? Do your clients believe that it can be?
Look, one cannot underestimate the harm that has been caused. One has to acknowledge that harm's been caused, and I think that everybody now realizes precisely what happened. We may not really appreciate the true extent of the decimation that occurred, but it most certainly occurred. Going forward, there's a commitment. The new commissioner of SARS has for a number of years put in place as measures to try and rebuild. And that's the tragedy, because prior to the decimation, SARS was rated in the top 5 revenue collection agencies in the world. We had that status. And now to go and have to rebuild, to try and regain that status, is an indictment on where our economy could have been had this decimation not occurred.
And, talking about, that issue of decimation, I'm going to borrow from what you've said in the public domain, and I'm hoping you can expand on it further. You say that the term rogue unit has caused so much hurt, and you are unhappy about this term continuing to be used. Let's talk about that.
That term, as I said previously, has been so abused and it's caused so much hurt, because what does the court say? And perhaps I'm going to read 2 passages from the judgment of judges Bakwa, Wendell and Basson, which will illustrate why this is so hurtful. The first paragraph says, the judges say, "This evidence is the most egregious failure of the public protector to understand and honor the most basic requirements of the office she occupies. It is plain that the public protector has approached this investigation with an unwavering commitment to her own preconceived views and biases." They also say, where a public office bearer does not hold herself to this high commitment to public service, as we have found this to be in this matter, a personal cost order is warranted. In the present case, we hold the considered view that the public protector has not met the requisite standards. The fact that the public protector displayed dishonesty in respect of the OIGI report is on its own deserving of censure by this court in the form of a personal cost order against her. Now, that's the words, those are the words of the judges themselves, who, for the first time, heard evidence from the very people who had the evidence and facts at their hands, but who were never, ever given the courtesy or the opportunity to have their say before the other forums. When I talk about the other forums, I'm talking about the various committees, the Sikhakhane panel, KPMG, the Kruan panel, and even the public protector herself. They were never given the opportunity to have their say. Instead, they were all vilified and they were called rogues. What the court has now said is there has never been anything such as a rogue unit. It was known as the High Risk Investigations Unit, and its job was to investigate and to tackle organized crime. That's what its task was. To call it a rogue unit is the most injurious label that you can give to people who are simply doing their best and trying to serve the country as best as they knew how.
And before we get to the issue of, the reparations, as we saw the statement by SARS, there's also, of course, the reality that in the public domain, and I'm sure you'd agree when we talk about this issue of decimation, as you've said, that opinions had already been formed when it comes to this issue of the rogue unit since the initial reports started emerging, through various media articles that we then saw over the years, some of those articles then being withdrawn. How do you then, begin with your clients to start then a process of changing some of the thinking around this? Because I'm certain for them, it is also worrying that some opinions have been formed and they may be difficult to change.
Indeed so. And this is unfortunately the tension between what I call the legal metronome and the media and public metronome. There's a cliche that the wheels of justice turn very slowly, and they do turn very slowly. The media metronome, the metronome of the public wanting answers right here and now and forming opinions based upon what they've read, but they don't take the trouble to follow the story right throughout to when a court may give a judgment a couple of years down the line, is precisely that problem. So how does one go forward? My clients and the others in the unit have to be very brave. They have been brave for a number of years. They've suffered tremendous torture, psychological, medical, family, you name it. But they have to be very brave. They have to know that there has been an apology. Can it undo what has been done? No. Has there been an acknowledgement that they were wronged? Indeed. And I guess with the support of friends and colleagues and the public acknowledging that they were vilified for no reason other than to advance state capture, they have to be courageous and look forward. And hopefully their lives going forward can be a little bit more pleasant than what the past, what they've had to endure in the past.
And if I may even borrow from some of the, the words from the statement from SARS, I mean, they say, although this cannot fully atone for the professional and personal harm they've suffered over a prolonged period, SARS hopes this reparations process brings some measure of healing and closure for the former SARS employees and the families, and enables both parties to move forward constructively. And you talk about, of course, the support that they will receive from friends and family, and up to thus far they've received to try and then move ahead. But in their view, is this process of atonement enough for them as they're getting these reparations, or is there a need for more in order to try and repair some of the public damage that has been done?
It's such a difficult question. I can't even begin to imagine. You're talking about real harm that have been caused to people. Some people have been able to manage it slightly better than others, but each one of them has in their own way had such harm caused to them. And that's why I say it's a lot of courage that's going to be it's going to take a lot of courage for them to move forward and say, you know what? We've received as much as we can. And it's not about the money, because the money's only part of it, but it's about restoring integrity, restoring humility, restoring faith, and trying to move forward. bearing in mind that we've still got a difficult road ahead of us. Unfortunately, we're living in very troubled times, not only in this country, but in the world. And so we've got to always be ever vigilant, never to allow such incidents like this to occur again.
Are you hoping that this ruling by the apex court, because we've seen in some instances where there could be a court ruling, but as we said earlier, some opinions will be formed. Are you hoping that this particular ruling now puts this matter to finality and shuts down the debate once and for all?
I would like to believe so. The apex court, the constitutional court, there is no other court in this country, has spoken. It should be the end of the road, and I think SARS themselves have embraced this, because after the Constitutional Court spoke, SARS came forward with their media release, and they too now, I believe, accept that this is the end of the road. One can never really comment on what others may do or say, but from a legal perspective, this is the end of the road.
Mr. Hotz, I'm going to ask you something a bit difficult, but I'm almost certain the viewers tonight would like you to take us behind, some of the conversations you would have had with your clients, during the course of this particular matter. Let's talk about the toll that it took on them, and give us a sense from a personal view on really what does this hurt that you talked about earlier look like, and this personal toll that it took on them mentally and otherwise.
I had throughout the case, I needed to familiarize myself with what work was being undertaken by this high-risk investigation unit in order to be able to tell the courts the story of the matters that they were busy with. Now, those matters, we're talking about organized crime. We're talking about very dangerous matters. People's lives are constantly at risk, and yet the commitment from these individuals, and it was a small group of people who only had the best interests of the country at heart. They were committed to putting their lives in danger 24 hours a day in order to make a real difference to the fight against organized crime. That was their life. That's what they did 24/7. All of a sudden, they were turned overnight into pariahs. They were accused of running brothels. They were accused of all types of heinous acts. They were accused of murdering people. It was absolute nightmare. Can you imagine having to look at your family, let alone friends and colleagues, look at your family and tell them it's not true? How can it not be true? Everybody's saying it's true, but it's not true. And they had to put their faith in the legal system, and I applaud them, because never once did they deviate from that path to say, we place our reliance in the legal system. We want an opportunity to be heard before a court of law, which is what happened. And that was the first time that they were properly heard. And when evidence was put before the court, in fact, I must also read a portion of the judgment from Judges Bakwa, Basson and Wendell, because this is what says it. It says, it is important to note that no other party in these proceedings, including the public protector and the EFF, has sought to respond at all to what Mr. van Lochenberg testified to in the affidavit deposed to by him. What he says thus stands entirely uncontradicted and unchallenged. The public protector has put up no facts or evidence, either in the report or in her affidavits filed in this matter, that refutes the evidence provided by Mr. Pillay and now by Mr. van Lochenberg. That was the first time that the facts were actually looked at, and the result was a resounding, there's nothing unlawful about this. They were only doing their job.
Mr. Hotz, thank you so much for that. I know it was a difficult final question that I had to ask you, but thank you so much for your time. Do appreciate it. And of course, let's see then what unfolds on this one. That's Bernard Hotz, a lawyer representing the former top SARS officials.